Ms. Champion, are you with me?
Yes, sir.
Is the jail on yet?
They have not signed on. I was just about to call out to courtroom 2.
Okay, if you'll do that for us, please, I'd appreciate it. Thank
Okay.
you. Good afternoon, everyone. We'll get started as soon as we have the jail on.
Good afternoon, Judge Morrow.
Good afternoon, Ms. McLeod. How are you?
I'm fine, thank you. I spoke earlier with the South Annex and I was told that they were having internet problems and they didn't think they'd be able to log on for court.
At all?
That was what I was told earlier.
Okay, well, thank you, Ms. McLeod. I appreciate.
You're welcome.
You know, so we'll continue to wait for their announcement. Apparently, they didn't tell the court personnel. So,
Yes, Your Honor.
thank you.
You're welcome.
And Your Honor,
Good afternoon, Ms. Gannett.
good afternoon, Your Honor. Regarding South Annex, positions 9 and 10, I submitted waivers of their appearance.
Okay, so yes, Ms. Champion.
I just spoke to courtroom 2. They said they should be signing on shortly.
Okay, thank you. So let's go ahead and do 9 and 10, if that's okay. Who is in position number 9, Martha Lowe? Oh, no, courtroom 2 is here. Good afternoon.
Yes, good afternoon, Judge Morrow. Sorry about that. We had the wrong Zoom number.
Okay, you're fine. Thank you. Where do you want to start this afternoon?
It's going to be in courtroom 2 with position 16, Mr. Shelton.
Good afternoon, Mr. Shelton. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. You've been charged in case 22 CR 006647G with battery family violence. Is there a history, Mr. Howard?
Second arrest. He's on probation in Gwinnett for ag assault. That's it.
Good afternoon, Ms. King.
Good afternoon, Your Honor. That aggravated assault is against the same victim for the case before, Your Honor. In those conditions for his probation, he was to have no contact with the victim. And he actually filed a motion to terminate that probation in March of 2022. The motion was denied, and less than a year later, he has offended again, Your Honor. This offense actually occurred on September 30th. Officers were actually called on October 1st to respond. When they responded, they spoke with the victim in this case, Tiara Williams, Tiera, last name traditional spelling. And she stated that the night before she and her husband were arguing. And during the course of the argument, he grabbed her by the arms and slammed her against the wall. He also pulled her hair to the point where she could hear her hair being ripped out. He also threatened her, stating, "You think I beat you before, you haven't seen anything yet." She told officers that she's in fear for her life and knows that the defendant will kill her if given the chance. The officers noted seeing substantial bruising around her eye and a busted blood vessel in her eye. And she said that initiated from a argument that occurred 2 weeks ago. She did not report that incident, but the officer did state in his report that the injuries sustained do coincide with the report that she was giving the officer. She stated that they had prior incidents with domestic violence, which is the aggravated assault previously referenced. And the officer also noticed that there were bruises on her arms and marks on her head that were also consistent with what happened to her the night before. At that point, the defendant was taken into custody. At this point, Your Honor, due to the defendant already violating against this defendant getting convicted for it and violating the conditions of his probation, the state is asking for $15,000 surety in this case. No further violent contact and a stay away from 6005 State Bridge Road, apartment 1433 in Johns Creek. And no drugs, alcohol, or weapons while out on bond.
No further violent contact?
My apologies, I misread the notes from my superior. It is no further contact, Your Honor. I just misspoke regarding the probation violations. They put no violent contact, Your Honor.
Okay, thank you, Ms. King. Good afternoon, Ms. King.
Yes, Your Honor. Mr. Shelton is 31 years old and he has been here in Georgia ever since 2000. So almost 22 years here in Georgia. And they reside together and they have 3 children together. However, 2 of them are Mr. Shelton's biological children, and the other one is stepdaughter. And also he's gainfully employed as a salesperson, and he has been working as a sales lead for about 1.5 years. He graduated from high school, and also he has done 1 year of college. He does have children to support, so we would like to request for actually $7,500 surety bond. That $15,000 surety bond sounds way too high, Your Honor. We would like it to be a little bit more reasonable. Thank you.
All right, so it's going to be a $7,500 good bond, no further contact with Ms. Williams, stay away from the 6005 State Bridge Road address. He can go back to that address on one occasion with law enforcement to retrieve any belongings that he might have there. If there are any minor children, there can be third-party transfer for visitation. No drugs, alcohol, or weapons while out on bond. Mr. Shelton, let me make it quite clear to you what no further contact means. It means no personal contact, no phone contact, no email contact, no contact over social media, no contact whatsoever until this matter is resolved. Do you understand me, sir?
Yes, sir.
All right, good luck to you, sir.
Next, we have position 8, Mr. Jones.
What is that? 18th? Okay. And this is Ronald Jones, is that correct?
Yes, Judge.
Thank you. Good afternoon, Mr. Jones. I'm Judge Eric Morrow. We're conducting this by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Jones, you've been charged in case 22 CR 006641E with battery, family violence, and cruelty to children in the 3rd degree, criminal trespass, and disorderly conduct. It's my understanding from pretrial that this is Mr. Jones's first arrest. Your case, Ms. Select, good afternoon.
Good afternoon, Your Honor. On September 30th, 2022, Officer Morgan with the Sandy Springs Police Department was dispatched to 3312 Glen Ridge, GLENRIDGE, Stratford, STRATFORD Drive in Sandy Springs. Upon arrival, Officer Morgan spoke with the victim in this case, Yamilet, YAMILETTE, Camille, KAMYL, Arvelo, ARVELO. The victim stated that she and the defendant lived together and share 1 child together. She also stated that her and the defendant got into a verbal dispute and the defendant punched her. It's a punching the victim to the Officer Morgan, and Officer Morgan was able to see bruising on the victim's right arm and lower back. The altercation occurred in the presence of their 6-month-old child, CJ. The defendant also threw a brick through the victim's window and damaged her mattress with a knife. The victim was so afraid of the defendant that she went to a neighbor's apartment and waited there until police arrived. While the victim was at a neighbor's apartment, the defendant began banging on the neighbor's door while screaming and cursing violently. The state is requesting a $1,000 surety bond on each charge and a stay away from the incident location, no contact with the victim, and third-party exchange for their 6-month-old child, 1-day anger awareness, and no alcohol, drugs, or weapons while out on bond, Your Honor.
Has your office spoke to Ms. Arvello?
One moment, Your Honor. No, Your Honor, but this incident just occurred on yesterday, so the state would be reinstating our recommendation as far as no contact in the third-party exchange.
Ms. Gant? Good
Thank
afternoon.
you, Your Honor. Good afternoon. Mr. Ronald Jones is 27 years old. He was born in Paterson, New Jersey, but he has been in the Atlanta area since 2017. He shares a 6-month-old with the complaining witness, Ms. Yamaletti Arvello. He also has 2 additional children, ages 1 and 2.5. Mr. Jones completed high school. He also has certifications as an EMT and a phlebotomist. He is currently employed at Life Hope Labs. He has been in that position since April of 2022. My client denies the allegations, Your Honor. He states that Ms. Arvello actually hit him and he more so pushed her away. He denies punching her. Your Honor, I am requesting a signature bond on Mr. Jones's behalf. This is his first arrest. He wants contact. I was able to speak with Ms. Arvello. She informed me that she wants the same. She should be on the Zoom call to inform the court of her wishes. Regarding conditions, I am opposed to the stay away and would ask the court for a no violent contact order. And again, a signature bond as Mr. Jones is recommended. If Your Honor determines that he is ineligible, then I would ask for a total bond of no more than $1,000, and that would be $250 for each count, Your Honor. Thank you.
And Your Honor, if I may.
Yes.
The state is actually amending its recommendation, $4,000 surety bond on the battery family violence and $1,000 surety bond on each additional charge due to the egregiousness of the facts of this case of him chasing her apartment complex and damaging windows and mattresses and using a weapon. Nothing further from the state.
All right, Mr. Arvello, if you are on the line and wish to be heard, this is your opportunity to do so. I'll need for you to unmute yourself and activate your camera if you would like to do so.
I'm here. I actually can't activate my camera for whatever reason.
Okay.
I'm not sure why.
Are you there under VIDOT?
Yeah, I am. That's me.
Okay. Can you raise your right hand, please?
Yeah. Let's see.
I see you on camera there. You're not driving, are you?
No, I'm in the car.
Okay. Can you raise your right hand?
Yes, you can see me?
Yes, I believe so.
Okay. I'm raising it.
Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, what would you like to tell the court? You can put your hand down, man.
Oh, okay. I would like contact. I do want some space though.
Say it again, ma'am.
I would like contact. I wasn't actually spoken to too much before this, so I'm not really aware on like everything.
Okay.
Uh,
You had to call the police in this matter?
I'm sorry. Oh, well, my phone was not connected due to him throwing it off of the balcony.
Okay.
I
Someone-
actually
Did
just turned
someone,
it on.
did someone call the police?
I'm sorry?
Did someone call the police in this matter?
Yes. Yeah,
Did
I never
you-
called. It was the neighbors.
Okay. And has this happened before?
No, it hasn't.
Are you afraid of him?
I'm
Okay.
not afraid of him sober. No.
Okay.
He's actually a great father. I can't say that he's not. He's great.
All right. Anything further, ma'am?
Yeah, I just think he needs to, it's the drinking, in my opinion. I know it is. That's all.
Right.
And Your Honor, may I ask a question?
Objection, Your Honor, objection. Ms.
Arvelo.
Arvelo has testified regarding her desire for contact, Your Honor.
Okay, yes, she has, but she's not testified in a way that I'm going to allow her to have contact. So, Mr. Lett, if your question goes to contact, then I think that should have been answered. Do you have anything else regarding this matter that you'd like to question Ms. Valero about?
You did go to the neighbor's house, correct?
Yeah, I did because I was
Because you were
scared.
afraid at the time?
Yeah, I was.
All right,
I
nothing
was.
further from the state.
Okay.
Thank you.
For the battery, it's going to be a $2,000 signature bond through pretrial. For the cruelty, $1,000 signature bond through pretrial. For the other two charges, a $500 signature bond through pretrial for each charge. Makes it a total of a $4,000 signature bond through pretrial, 1-day anger awareness. At this point in time, no further contact with Ms. Arvelo, given the nature of her testimony today. Stay away from the 3312 Glenwood Stratford Drive address. He can go back to that address on one occasion with law enforcement to retrieve any belongings that he might have there. There's to be third-party transfer for visitation of the children, and no drugs, alcohol, weapons while out on bond. Mr. Jones, let me just let you know that if you violate this bond in any way, you're going to be right back there where you are. And specifically, that means that I have ordered no drugs or alcohol while you're out on bond. If you violate that stipulation also, you'll be in violation of this bond. Good luck to you, sir.
Thank you, Your Honor.
Position 4, Edwards.
Good afternoon, Mr. Edwards. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video. Do you agree to have your case heard by video? Yes? Is that a yes?
Yes.
Okay. Mr. Edwards, you've been charged in case 22 CR 006638J with battery family violence. Is there a history, Mr. Howard?
6 adult arrests. Last arrest was in March, battery obstruction. He has open terrorist threats and battery and felony, 20 CP 193758. On probation for trespass, damage to property, 21 CR 004522J. Also on probation for battery and obstruction, 22 CR 001580J. Yeah, that's pretty much it. He got a 2018 simple battery that was dismissed. And before that was a 2017, that was his juvie arrest. So every arrest violent, but yeah, every arrest is violent.
Thank you, Ms. Lett.
Yes, Your Honor. On August 29th, 2022, Officer Harris with the College Park Police Department responded to 1611 Harvard Avenue, apartment 19, and made contact with the victim in this case, Shanetta Reed. That's SHANNETTA. ID. Ms. Reed is the mother of the defendant, and she stated that she got in a verbal altercation with her son, the defendant, and the defendant became angry with her. And the defendant grabbed the victim by her shirt and punched her several times in her face, causing bruising and small lacerations to both of her left and right eye. As far as his previous arrest, in 2017, there was a simple assault, criminal trespass, where the victim in this case is the same victim in that case. It was closed out with diversion, but the March 2022 conviction of criminal damage to property, that case had the same victim as well. And so he's on probation, not supposed to have any contact with Ms. Reed. And so he is in violation of his probation at this time. The state would be asking for a $10,000 bond, no contact with the victim, Shanetta Reed. Stay away from the incident location, 1611 Harbor Avenue, apartment 19. No alcohol, drugs, or weapon. Family violence intervention program, and stay away, I already said that, stay away from the incident location due to his violent history and history with the same victim and his violation of probation. That would be the state's recommendation at this time, Your Honor.
Thank you. Ms. McLeod?
Yes, Your Honor. My client is 22 years old. He tells me that he is currently employed, although he was previously employed in the hospitality industry. He does have a high school diploma, Your Honor. He denies the allegations. In fact, he said he was actually at his sister's home when his mom came over there. He tells me that she at some point had a restraining order against him and she was not supposed to come around him, but she came to where she knew he was going to be. And he denies that he put his hand on her at all. He did say that his sister would be able to testify that that was the case, but I did try contacting his sister and was unable to, Your Honor. But he tells me that that did not happen, and that is absolutely untrue.
Right.
Your Honor, he's not employed right now, so he is not in a position to pay any money towards bond, and I would ask the court to take that into consideration in setting his bond.
All right. It looks like he's agitated there, Ms. McLeod. I don't know if he needs to speak with you before I set bond.
Okay.
It's not really no more.
Yeah.
Mr. Edwards, do you need to speak with me? Because I can call.
I do. Okay, so like you were saying, she do have a restraining order on me. For some reason, I was trying to see, can I get one? Because she always find her way back around.
We spoke about that already, Mr. Edwards, and I'll give you instructions about how you can get one.
I have something necessary. So I was
okay, Mr. Edwards. Let me just say, you have a right. You have a right to remain silent. Anything you say can be used against you. Just know that sometimes people think that they can say something and it's going to be helpful for their case when in actuality it's just the opposite. So, as Ms. McLeod is advised, you do have the right to remain silent. So you have solicitors on here that are listening to everything that you have to say. So you should take that into consideration. Okay.
But I still want to speak. I'm aware of all that.
Okay. Ms. McLeod?
There is a way you can get a restraining order.
No, I'm past that. I have something else to say.
I would advise you not to talk about the facts of your case or what is going on between yourself and your mom right now.
It's not about, well, it is about the case, but I'm just saying, I feel like I should say it anyway. You get what I'm saying? I'm aware that anything I say could be used against me. I'm aware of all that. But this is what I'm saying. If she have a restraining order on me, she shouldn't be having no ties to nothing I got going on. She have ties to my benefits and everything. All that needs to stop. If she don't have a restraining order on me, because that's what I'm in here for. She just want to use the money for herself. So
okay, Mr. Edwards, I think you shouldn't say anymore. I think, Your Honor, what he's saying is that he gets disability benefits and his mom has been trying to access them and she keeps coming around him in order to get information to access his benefits.
Okay. It's my understanding that Ms. Reed is on the line. Ms. Reed, if you would like to address the court, this is now your opportunity to do so. You do not have to address the court. But if you would like to address the court, you're going to have to unmute yourself and activate your camera. Would you like to address the court, Ms. Reed?
Yes, sir, I would.
You raise your right hand for me.
No, right.
Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Put your hands out. I don't want to hear all the backstory, Ms. Reed. I wanted to hear about this battery family violence that occurred on August 29th, okay? So anything that you want to tell me about that and your son, I'm happy to hear about, okay?
Okay, sir. On that particular day, I went to Mechanicsville where he was staying, and he was one had started being violent and just having an attitude with me. I was taking him to work and stuff. It got and he was doing my deliveries with me, and it had just got he just started getting all angry again. So I went over there to ask the people what was the problem. So they evidently told him that I came to, find out why was he angry again. So when I got to, because I had done wash my clothes, put them over at my daughter's house, 1611 Harvard, and he came and said, I heard you went over there showing them my paperwork. I had my Wonder half cop, and he just reached in, and when I told him I didn't care, he reached in and he punched me. He tore my shirt, and this is not the only time. He done brought people into the house to fight his brother and stuff, and I got him right here with me. And I mean, Warren just been violent since 3rd grade, and it's getting ridiculous. So I recommend that he get some help for himself. He needs to seek counseling, because I did everything I could for my children, and I just feel like he hates me in some kind of way. I'm out here now trying to get a job with Allied, or I don't got hired with Allied. But Judge, Your Honor, if you can please, I mean, I brought my kids to love one another and all of that. And this is, I mean, it brings me to tears that a child will put their hands on their mama. I've been through enough with the death of their daddy and the way that he was buried. I just need some type of help with you all, judge, to just help get him in some type of program or sit him down or something, because he don't already got shot 3 times, and this is ridiculous.
Okay, thank you, Ms. Reed. Ms. Reed, do you have a restraining order against him?
I don't have a restraining order, sir. I just had to have him locked up so that we can go to the court to address what is his problem. I mean, he got a problem with me. He got a problem with his brother sitting right here. He don't, he beats up people and just stays in chaos. He gonna, sir, after a while, somebody gonna kill him.
All right, thank you, Ms. Reed. I appreciate you speaking to the court. Anything further from counsel? Okay. If not, $5,000 good bond. No further contact with Ms. Reed. Was there a stay away asked for, Ms. Salette?
Yes, Your Honor.
What is the stay away address?
1611 Harvard Avenue, apartment 19, College Park.
And no drugs, alcohol, or weapons while out on bond. All right, thank you, Ms. Reed, and good luck to you also, Mr. Edwards. Who do we have next?
I'm sorry, Judge, what was the bond?
5,000 good bond.
How much?
5.
Okay, thank you.
And I have another question. What do I do about a restraining order? Because she has one. That's why I tried to get my sister on here.
Mr. Edwards, you and I can talk about that.
Okay, so do you have a number or something I can call you with?
Yes.
Okay, can you
The officer will give you my number. I'll just ask them for it.
Okay.
Position 20 Woods.
Yeah, that's my good.
Good afternoon, Mr. Woods. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Yes, thank you, Mr. Woods. You've been charged in case 22 CR 006649Y with a fray. Is there a history, Mr. Howard?
The second arrest. He has an open ag assault strangulation and ag assault 22 SC 182921. That's it.
Ms. King?
Yes, Your Honor. He's out on a $30,000 signature bond for that felony case. And that case does not involve the victim before Your Honor. On October 1st, officers responded to a fight in progress call at 946 Cruz Street at around 9 p.m. Upon arrival, they met with the victim in the case, Derek Mitchell, DERRICK, last name MITCHELL. And he stated that he had an altercation with the defendant, who is his next door neighbor. When asking why the altercation took place, he stated because the defendant knocked on his door. At that point, they went into the yard, and that's where the fight took place. At some point, the victim in this case hit his head on the gutter of the home that they were at, and there's a laceration in the back of his head. More facts came out, Your Honor, and it was also brought out that, well, it was alleged that the victim in this case discharged a firearm in the air, but that wasn't substantiated, which is why he was not arrested as well, Your Honor. While this defendant does not have a lengthy criminal history, we are concerned that the only 2 cycles he has are violence, Your Honor. For that reason, we're asking for a $5,000 surety, no further contact with Derek Mitchell, or stay away from the incident location, and no drugs, alcohol, or weapons while out on bond. I'll also like to say to the court that he's already received a hefty signature bond, which he violated in this case. So the state would object to any signature bond in this case under those facts.
Ms. Kim?
Yes, Your Honor. Mr. Woods is 41 years old, and he does have, he actually resides with his mother right next to complaining witness, Mr. Mitchell Derrick. Indeed, he was attacking his mother, and Mr. Woods wanted to protect himself and his mother because Mr. Derrick actually used a gun and fired. It was very, very intimidating and scary to both mother and son. My client actually acted out of his self-defense for himself and his mother. He does not have any children. He's not married. However, he has other family members here in Georgia. He lived here for all his life, and he's been working as a custodian at the hotel for about 20 years. He graduated from high school, and we would like to request for signature on bond. He's presumed to be innocent, and this case, he's very, very, it was him who had to protect his mother and himself. Thank you.
All right, it's going to be a $5,000 signature bond through the jail. No further contact with Mr. Mitchell. Stay away from the 946 Crew address. No drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Woods.
Yeah. Position 15, Santiago.
Good afternoon, Mr. Santiago. I am Judge Eric Mora. This is the State Court Expedited Accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you. You have been charged in case 22 CR 006646C with driving under the influence of alcohol less safe, improper erratic lane change, possession of marijuana less than an ounce, and driving under the influence of alcohol and drugs. Is there a history, Mr. Howard?
Yeah, second arrest. I got a 2017 shoplifting that was dismissed after diversion.
All right, Ms. King.
Yes, Your Honor. This offense occurred on October 2nd. Officers conducted a traffic stop on Medlock Bridge Road and Grove Point Road in Johns Creek after seeing the defendant fail to maintain his lane. When he made contact with the defendant, he could smell the odor of alcohol. He also had slurred speech and glassy eyes. He asked how much he had to drink that night, and he stated 1 beer. At that point, the officer asked him if he would participate in the standardized field sobriety test, which the defendant agreed to. The HDN had 4 out of 6 clues, walk and turn 2 out of 8 clues, and the one leg stand is 1 out of 4 clues. Based on the officer's experience and training, he determined the defendant to be under the influence of alcohol to the point where he was unsafe. Implied consent was read and the defendant gave a verbal yes. The results of that test is 0.051. While this is not above the legal limit, the officer's observations of how he was driving showed that he was still less safe to drive. For that reason, the state is requesting a $5,000 split bond. That's $3,000 surety on the DUI less safe and $1,000 signature on the other charges. Limit the driving to work, school, emergency medical care, and visiting his attorney, and no drugs, alcohol, or weapons while out on bond.
All right, Ms. Kim.
Yes, Mr. Kenny Santiago is 22 years old, and he was born and raised here in Georgia for 22 years. He resides with his mother, Emma, and he is working as a driver for a drywall company. He's been working there from June 2022, and he wants to keep his job, so he has to drive for his work. He graduated from high school, and also he's enrolled in Georgia State University, and he is currently dropped out of the school to take care of his mother, who is physically in need for his help. And this is, again, not above the legal limit. We would like to request for a signature on bond so he can go and take care of his mother. Thank you.
All right, so for both DUI offenses, it's going to be $1,000 signature bond through the jail. For the improper erratic lane change, a $250 SOB through the jail. For the marijuana, $250 SOB through the jail. So it's going to be a total of a $2,500 SOB through the jail. No drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Santiago.
Thank you.
All right. Position 13, Perry.
Good afternoon, Mr. Perry. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. You have been charged in case 22 CR 006644J with battery family violence. I've been told by pretrial that this is his first arrest. Ms. King.
Yes, Your Honor. This offense occurred on September 1st. Officers were dispatched to a domestic disturbance at 6624 Virlin, VIRLYN, B. Smith Road in Fairburn. Upon arrival, they met with the victim, who is a juvenile. His name is William Charles Perry, all traditional spelling. And he stated that his father, who is the defendant, hit him in the face, cutting his nose. And the officer noted seeing a big gash on the victim's nose that was actively bleeding when the officer arrived. The victim stated that his father took his video game console and they were arguing, and the culmination of that was the defendant striking him in the face with the console. They also had 2 independent witnesses at the scene, the victim's mother and the victim's brother, who both corroborated the victim's statements regarding how this happened. And they also confirmed that it was not in self-defense or trying to stop the juvenile from doing anything. The defendant was being the aggressor in this situation, Your Honor, which is why he was taken into custody. We have spoken to the victim's mother in this case. She states that this never happened before. And while she's asking for contact, the state is opposed to that due to the egregious nature of this offense. You know, there's corporal punishment, and then there's hitting someone in the face with a video game, Your Honor. The victim's mother also states that the defendant is from the military and can be a little strict. For that, we are a little concerned about the safety of the people that live in the home, because if this is how he reacts to any kind of defiance, we're concerned that he may do this again or something worse, Your Honor. For that reason, we're requesting a $3,000 surety in this case, no further contact with the victim in this case, a stay away from the incident location, and no drugs, alcohol, or weapons while out on bond.
How old is the alleged victim?
16, going to be 17 in December, Your Honor.
Okay, thank you. Go ahead, Ms. Kim.
Yes, Your Honor. Major Perry is 51 years old, Your Honor, And he has been here in Georgia for about 25 years. And he has 3 children, 27, 20, and 16, who's going to be 17 in December. He's married, and he has, of course, he's a major in military army. He's been soldier for about 34 years, and he has a master's degree in logistics and supply. He says he denies the allegation for intentional battery. It was more corporate punishment, that he just wanted to make sure that he was not playing with a video game too much. We would like to request for signature on bond, and also no violent contact. That is Mr. Major Perry's house, 6624 Verlaine, and they all reside together. So I think it would be better to have no further violent contact. Thank you very much.
Oh, Your Honor, very briefly. The mother did take the victim to get medical attention, and the laceration was so deep that it had to be glued back together, Your Honor. I just wanted to let the court know that.
Thank you. It's going to be a $3,000 signature bond through pretrial, 1-day anger awareness, no further violent contact with the alleged victim, and no drugs, alcohol, or weapons while out on bond. I'm going to let you out, Mr. Perry, by signing your own bond, but if you violate any of these conditions, then you're going to be right back where you are, okay? Good luck to you, sir. Who do we have next? You're on mute, courtroom 2. Thank
Sorry, Judge. Position 12, Monroe.
Good afternoon, Mr. Monroe. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. You have been charged in case 22 CR 006643C with simple battery family violence. So your history, Mr. Howard?
11 total. Last arrest was 2019 for trespass, death by taking, and terrorist threats. He's on probation for that in Henry County. 2021, they gave him 5 years probation. He has history out of North Carolina. 2009, assault by strangulation conviction, assault on a female conviction. He has a 2009 assault pointing a gun, kidnapping, false imprisonment. What else we got? 05 simple afraid conviction, and a 05 simple assault conviction.
Thank you. Good afternoon, Mr. Torrey.
Good afternoon, Judge. How are you?
Doing well, thank you. You can proceed.
Yes, Judge. So in this case, on October 2nd, 2022, at approximately 6:00 p.m., police were dispatched to a Dollar General in reference to a fight call. That evening, the defendant and the victim met up at Dollar General to exchange a child that they share. As the defendant was loading the car seat in the victim's vehicle, he asked her when he could meet her new boyfriend. Once the defendant securely placed the car seat in the vehicle, he lunged towards the victim and grabbed the collar of her shirt in an aggressive manner. Judge, the state's bond recommendation is a $10,000 surety bond. No further contact with the victim, Asia Chapman, and that is spelled A-I-S-I-A, Chapman, C-H-A-T as in Tom, M as in Mary, A-N. Stay away from the incident location, 4837 Roosevelt Highway in Atlanta, Georgia, 30349. Completion of a 1-day anger awareness course, and no drugs, alcohol, or weapons while out on bond. And Judge, the state is concerned that the defendant serves as a flight risk due to being a multi-state offender. As you heard Mr. Howard mention the history, which is most of his convictions were out of North Carolina. Furthermore, he runs the risk of reoffending, and he poses as a danger to the community due to the violent nature of this current charge, in addition to his violent past convictions and arrests. To make matters worse, Your Honor, he's currently on probation for a 2021 case out of Henry County against the very same victim. Judge, I contacted Henry County DA's office, and as part of the probation conditions, he's to have no contact with the victim, in this case, Ms. Chapman, with the exception of a supervised exchange of the child pertinent to the family court order. Judge, we also spoke to the victim, and the victim stated that she is in fear of her safety. She absolutely wants no contact whatsoever. She did mention the details of the case that he is currently on probation in Henry County. She also stated that she had a TPO on the defendant that expired in February 2022. She stated that she is currently planning on filing another TPO today and plans to add their child to that TPO due to this occurring in front of the child. Judge, I also do see the victim is on the Zoom call, and she would like to address the court, and if the court would sound for her when appropriate.
Thank you. Ms. Kim?
Yes, Your Honor. Mr. Monroe is 33 years old. We have no objection to stay away or no further contact, as long as he can meet his son, who is 2 years old. He has 50% of child custody. They went through the legitimation, and he has a right to see his child. He has 2 jobs, working really hard at warehouse for the last 9 years. He graduated from high school, and he has 1 year of college, and he has been here in Georgia 10 years. He's not going to go back to North Carolina, certainly. He currently has a seizures. He has a high blood pressure, and he has a special medical condition where he needs to have some attention. So we would like to request for a signature on bond. And yet, if Your Honor is not inclined to give him a signature on bond because of the probation from Henry County, we would like to request for a maximum $1,500 good bond. Thank you.
Ms. Chapman, this is your opportunity to address the court if you would like to. You're not required to, but if you would like to, you'll have to unmute yourself, activate your camera, and I'll have to swear you in. Okay, can you raise your right hand for me? The other one?
I'm sorry.
Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down, ma'am. What would you like to tell the court?
That I do agree with her. I do not want any contact with Mr. Monroe. And right now we don't have anybody in place that will be able to be an exchange for him to get our son. I feel like my son is in danger to be with him during the time of visitations. And that's just all I want to say.
Okay, thank you, Ms. Chapman. Anything further, counsel?
Nothing further, Your Honor.
All right, it's going to be a $5,000 good bond. No further contact with Ms. Chapman. Chapman, stay away from the 4835 Roosevelt Highway address. No drugs, alcohol, or weapons while out on bond. Excuse me. As far as this bond goes, if there does become someone that can conduct a third-party transfer, I'm not going to keep him from his child, but Mr. Monroe, you cannot have any contact with Ms. Chapman. Therefore, you're going to have to go through someone independent to have visitations with your child. Good luck to you, sir. Ms. Kim, your client has his hand up.
Mr. Monroe, please stay silent. I'll give you a call so we can discuss further.
Next.
I just have one question.
Mr. Monroe, I'll call you. Is it about bond, directly related to the bond condition?
Yes, ma'am. Yes, ma'am.
Yes.
Is my mute?
Go
Yes, sir. I was just trying to see if I could get a signature bond because I work 2 jobs. I go in from 6:30 and 3 o'clock to 11. Sometimes one I get.
Okay, slow down, Mr. Monroe. Again, you have a right to remain silent. Anything you say can be used against you, sir. I suggest that you talk to Mrs. Kim. I've already made my bond for you on this matter, and that takes into account your not only what happened in this instance, but what's happened in the past also. So it's a $5,000 good bond at this point in time, sir. Good luck to you.
Position 11, McRae.
Good afternoon, Mr. McCray. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir, Your Honor.
Thank you. You have been charged in case 22 CR 006650F with improper erratic lane change, expired or no license plate or decal, driving under the influence of alcohol less safe, possession of an open alcohol container, and DUI concentration of 0.08 grams or more. Is there history, Mr. Howard?
First.
Ms. King?
Yes, Your Honor. This offense occurred on, October 2nd. The officer observed the defendant failed to maintain his lane on Georgia 140 and Old Alabama Road in Roswell. Upon stopping the defendant, he also determined that the registration of the vehicle had expired 5 months prior to this. When he made contact with the defendant, he noticed that his eyes were red and watery, his speech was slurred, and he smelled the odor of alcohol on his breath. Field sobriety tests were done, and it was determined that he was impaired and too impaired to drive, Your Honor. The officer also noted seeing a cup of white wine that was in the passenger compartment that had the strong smell of odor and visually looked like white wine, Your Honor. The defendant submitted a state-administered chemical test of his breath, and the results were 0.086, which is above the legal limit, Your Honor. For that reason, the state is requesting a $6,500 split bond. That's $3,000 surety for the DUI per se, $2,000 signature for the DUI less safe, and $500 for each of the other charges. Limit the driving to work, school, emergency medical care, and visiting his attorney, and no drugs, alcohol, or weapons while out on bond.
Right. Ms. Kim?
Yes. Mr. Patrick McCready is 53 years old, and he has been here in Georgia for all his life. He has 2 children, who one of them is still minor that he's taking care of, and he has his family members here in Georgia. He has a strong ties to the community, and he has a job as a salesperson at Telecom. He's been doing that for about 4 years. And also he graduated from high school, and he has a bachelor's degree from a university. And we would like to request for signature on bond since this is his first one. Thank you.
All right, so for the erratic lane change, a $250 good bond, no decal, $250 good bond, DUI less safe, $1,000 good bond, open alcohol container, $250 good bond. The other DUI, $1,000 good bond, makes for a total of a $2,750 good bond. No drugs, alcohol, or weapons while out on bond. Good luck to you, Ms. McCray.
Thank you.
Position 7, Jackson.
Good afternoon, Mr. Jackson. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
Thank you. You have been charged in case 22 CR 006640F with simple battery family violence. I've been told by pretrial that this is his first arrest. Ms. Salette.
Yes, Your Honor. On September 30th, 2022, Officer Clairvaux with the East Point Police Department was dispatched to 3201 Kenilworth Drive, KENELWORTH, apartment 5 in East Point. Upon arrival, Officer Clairvaux spoke with the victim in this case, Andrea Marion. That's spelled ANDREA. Marion. Ms. Marion and the defendant are in a relationship and reside together at the incident location. Ms. Marion stated that she and the defendant got into a verbal argument about the defendant playing a video game. Ms. Marion unplugged the video game and the defendant became irate. Ms. Marion began recording the defendant and excuse me, Your Honor, and the defendant slapped the cell phone out of the victim's hand. And this could be seen on the victim's recording of the incident from her phone, which Officer Clairvaux was able to view on that date. The state's recommendation is a $2,000 surety bond, no contact with the victim, Andrea Marion, and stay away from the incident location, no alcohol, drugs, or weapons, and a 1-day anger awareness.
Yeah.
Thank you, Your Honor. Mr. Everett Jackson is 31 years old. He has been in the Atlanta, Georgia area for 1 year. He has 2 children, ages 9 and 6, and young Mr. Jackson completed high school and some college in the area of computer electronic technology. He is employed with U.S. Foods and has been so for the past 6 years. He wants to continue having contact with Ms. Marion. We are opposed to any no contact and stay away orders. I did have the occasion to speak with Ms. Marion. She informed me that she wants to have contact, and I believe that she is on the Zoom call. Lastly, Your Honor, Mr. Jackson strongly denies the allegations. He states that he was merely trying to get his cell phone back or to retrieve his cell phone, Your Honor. I am requesting a signature bond for Mr. Jackson. This is his first arrest. He does not have any prior history of violence. And again, we are opposed to any stay away and no contact orders. Thank you.
Okay, Ms. Marion, this is your opportunity to address the court if you choose to. If you would like to address the court, you'll have to and activate your camera, and I'll have to swear you in.
I am here. I am trying to activate it. It's giving me an error saying unable to.
Okay, I believe I see you there under Marion's iPhone.
Yes.
Can you raise your right hand for me? Can you raise your right hand for me?
You see it? It's raised.
Okay, now there are 2 Marion's. Well, that's Marion's. No, ma'am, I cannot see. I think you have the large A. Can you try?
Trying to start it again. Can you see me now?
Can you hear me, Miss Marion? Ms. Gant, you did have the opportunity to speak with Ms. Marion prior to the hearing today,
Yes, Your Honor.
and she informed you that she did want contact.
Yes, Your Honor.
Anything else that you can inform the court of?
Your Honor, that she wants contact, and we are opposed to the no contact and stay away orders, and would ask the court for a no violent contact order.
Okay.
I'm sorry, I'm here. Can you see me?
Yes, I can see you now, ma'am. Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. What would you like to tell the court?
Me and Mr. Jackson been together for 6 years. We have never had an incident like this before. It honestly just was something that just escalated over nothing. And I can say on my part, because I was frustrated, I did unplug the TV, which caused the situation to escalate further. I was not going to call the police. I just honestly wanted my phone back. So when he slapped it down and took it, I just wanted to leave. But again, I'm new to Georgia, so I need my phone in order for me to leave, to go anywhere. We Google Maps, everything. That was honestly the only reason why I called, because I just wanted my property back. But other than that, we never had any issues. I never called the cops before. We literally moved here from our hometown together. We never had any issues. So I'm not afraid or scared or anything like that. It was just a situation that escalated, which I can't say on my part I did cause it to go further by unplugging the TV, which made the situation a little bit more irate.
All right, thank you, ma'am. Anything further from counsel?
Nothing from the defense, Your Honor.
It's going to be a $2,000 signature bond through pretrial, 1-day anger awareness, no further violent contact with Ms. Marion, and no drugs, alcohol, or weapons while out on bond. All right, good luck to you, Mr. Jackson. You also, Ms. Marion.
Thank you, Your Honor.
Thank you.
Position 6, Hector.
Good afternoon, Mr. Hector. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. You've been charged in case 22 CR 0066528 with simple battery family violence. Is there a history, Mr. Howard?
This is third arrest. I got a 2009 fade to appear out of Alabama. 2009 traffic offense, no insurance. That's it.
Ms. Salette?
Yes, Your Honor. On October 2nd, 2022, Officer Reuter with the Hapeville Police Department was dispatched to 3579 South Fulton Avenue in Hapeville. Upon arrival, Officer Reuter met with defendant's mother, Trudy Tillman. Ms. Tillman stated that and the victim, Brittany Young, had been arguing since the day before. Ms. Young and the defendant are in a relationship and share children and reside together at the 3579 South Fulton location. Ms. Tillman stated that she witnessed an argument between the two, and as it got worse, the defendant charged towards the victim and pulled her hair. The defendant had to be separated from the victim by family members, and the defendant fled on foot. Once Officer Reuter was able to locate the defendant, he admitted to grabbing the victim and said that he knew he was wrong for what he had done. The state's recommendation is a $2,000 surety bond, no contact with the victim, Brittany, Brittney, Young, Young. Stay away from the incident location, no alcohol, drugs, or weapons, 1-day anger awareness, and third-party exchange for their children, Your Honor.
Ms. Gann?
Thank you, Your Honor. Mr. Derek Hector is 35 years old. He has been in the Atlanta, Georgia area since 2012. He shares 2 children with the complaining witness, Ms. Brittany Young. Children are ages 2 years and 1 month. Your Honor, Mr. Hector graduated Morehouse in 2018. He is a business owner in Trusted Capital. He has been in that position for the past 2 years. However, he informs me that with COVID in the economy, his business is not as profitable. Your Honor, Mr. Hector denies the allegations. He's presumed innocent at this point. He does not have any convictions for violence, and his in fact, his arrest history is remote for traffic offense, Your Honor. I'm requesting a signature bond on Mr. Hector's behalf, and I did have the occasion to speak with Ms. Young. She states that she wants contact with him. My client wants contact. Therefore, Your Honor, I'm requesting a no violent contact order, and we are opposed to any stay away provisions. Thank you.
Ms. Young, I see you on the line. If you would like to address the court, now is your opportunity to do so. If you would like to, you'll, there you go. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
I do.
Put your hand down, ma'am. What would you like to tell the court?
I just wanted to make one point of distinction. He didn't flee, he just walked to the park, and once he recognized that there was an officer there, his mom told him that they were going to be looking for him. He voluntarily walked up to have a conversation. So I just kind of wanted to correct that understanding at the onset. Derek is a great father. He's a great, man in general. We had been arguing for a while, and it did escalate, and unfortunately it had to escalate to the point that it did. I'm not opposed to contact as long as it's not violent. I would prefer not to do third-party exchange with the kids. I would like at least some type of anger management or counseling the 1 day, because the situation did escalate to the point that it did. And I personally don't believe that a financial penalty or jail time is the answer here. I just think there needs to be, some type of counseling to be able to learn coping skills, to work through, any type of feelings that you may have in a more positive and productive way. His family's here with me now. So, we have that support system to be able to, kind of get on the other side, or, help him get on the other side of this. So that's what I wanted to share.
Okay, thank you, ma'am. I appreciate it. It's going to be a $3,000 signature bond through pretrial, 1 day anger awareness, no further violent contact with Ms. Young, no drugs, alcohol, or weapons while out on bond.
And Your Honor, if I may ask Ms. Young a question, because she told our office something different. So I just wanted to clarify
Go on,
one point.
Go ahead, Ms. Salette.
Ms. Young, did you tell Ms. Cheney from our office that you did not want the defendant back in the home, but you were okay with contact?
Yes, I think we need space and time apart, so I don't think we need to live together, but I'm okay with him coming to get his things. That's why his parents are here. But we do need space and time apart, but we don't have to have third-party exchange. But in terms of us living together day to day, we do need some time apart. So I'm not sure what was different than what I previously stated.
Because
Your Honor, this
hold on, Ms. Slid. If I order no further contact, he can have no contact with you whatsoever. No phone contact, no personal contact, no email contact, no contact whatsoever.
Well, I thought it was no violent contact, meaning the way she explained it to me was that we can have contact, it can't be violent contact.
Right, which is what I ordered, which was the no further violent contact.
Right.
But if you're telling me that you don't want him back in the home, then that means no further contact.
Your Honor, I was going to ask for a stay away. And I mean, the state's position is that there should be no contact, but if you are going to allow contact, the state would ask that there be a stay away from the incident location and that he be able to come back and retrieve his items with the law enforcement officer one time.
Is that what you want, Ms. Young?
Yes, I think that that's fair. How long does that last?
Until this is resolved.
Okay, I mean, I think that that's fair, but I think I'm open to us having contact. We have children, so I don't want third-party exchange. I want him to be able to freely contact his children via FaceTime or any method that, is preferred.
Okay, so it will be no further violent contact with you, but he's going to have to stay away from the 3579 South Fulton Avenue address. He can go back to that address on one occasion with law enforcement to retrieve any belongings that he might have there.
Okay.
Okay?
Mhm.
Good luck to you all.
Thank you.
Thank you, Your Honor.
Position 5, Felders.
Good afternoon, Mr. Felders. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you. You've been charged in case 22 CR 00669C with battery, family violence, and cruelty to children in the 3rd degree. Is there a history, Mr. Howard?
He got over 20 arrests. He was arrested January of this year for strangulation and suffocation, battery and disorderly conduct out of Milwaukee. He had a August 2021 battery that was dismissed, 2018 battery dismissed, 2018 false imprisonment, assault and battery. I don't see a disposition for that. 2017 battery dismissed. Another 2017 arrest for disorderly conduct, dangerous weapon. Got a 2016 battery, disorderly conduct dismissed. Yeah, everything else is much older.
All right, Ms. Select.
Yes, Your Honor. On September 30th, 2022, officers from East Point were dispatched to 4502 Parkview Square in East Point, Georgia. Upon arrival, Officer Whiteley noticed blood and wounds on the victim's head, Miss Marion Hackworth, MARION HACKWORTH. Ms. Hackworth and Officer Watley that she was speaking with the defendant earlier that evening and let him know that she had found an overnight daycare for their children. The defendant became upset and told her that she was trying to pull something slick. The defendant then grabbed her and dragged her down the stairs and began punching her and slapping her. The defendant then slammed her head against the countertops in the kitchen, which caused gash wounds on her. The victim said that she could feel blood dripping from her head, and at first she thought it was water, but her daughter, who was present at the time of the incident, began screaming when she saw the blood. The defendant took the 5-year-old daughter from the scene, and the victim went to the children's daycare in order to retrieve their other child. In the event that the defendant went to the daycare and tried to get to the other child, once she arrived at the daycare, that's when she called the police and police officers went back to the incident location, and she was able to report everything that happened at that time. We know for sure that his last four arrests out of Milwaukee, the victim in this case is the same victim in those cases, Your Honor. And the victim is present on the Zoom today to speak on her behalf. The state's recommendation based on the defendant's violent history, this violent case at hand, and his history being out of state, him being a multi-state offender, the state's recommending $20,000 surety bond on the battery family violence charge and a $5,000 surety bond on the cruelty to children in the third degree. The victim is very afraid of the defendant and is in fear of her life. The state is also asking for a stay away from the incident location, which is that 4502 Parkview Square, East Point address. No contact with in this case, one name alcohol, drugs, or weapons while out on bond, Your Honor. Yes.
Okay, you bleeped off for a moment, Ms. Salette. So I think the last thing I heard was a stay away from the Parkview Square address. Was there something else after that?
Yes, Your Honor. No contact with the victim in this case, Marion Hackworth, and also no contact with the children. The children's name, the first one is Courtney Felder, and that's Courtney spelled with a K, Kourtney Felders. And one moment for the other child's name, Your Honor.
All right, while she's getting that, Ms. Gant.
Thank you, Your Honor. Mr. Courtney Felders is 41 years old. He was born in Indiana and has been in the Atlanta, Georgia area for 1 year. He has two daughters, ages 3 and 5. Mr. Felders completed high school. He has some college in business management. He is currently employed at Hope Home Realty. He has been in that position for the past 2 years, and he informs me that he has to prepare a property for rental. Your Honor, he strongly denies the allegations. He states that the complaining witness, Ms. Hackworth, is just content on making false allegations against him. We heard from pretrial that he did have quite a few arrests that led to dismissals. He strongly denies any allegations whatsoever. He states that for the arrest back in January, he tells me that that case was dismissed on September 12th, 2022. He again insists that this is a ploy by Ms. Hackworth to get custody of the children. He states that he, in fact, has custody that was granted by Wisconsin. He also is receiving the state's assistance in terms of just healthcare and food expenses for the children, Your Honor. We are unopposed to the stay away at the incident location, but I would bring to the court's attention that Mr. Felders, his address is 4504, and the complaining witness's address is 4502, and it's the same street. So apparently they're near each other. So we are unopposed to Mr. Felder staying away from Ms. Hackworth's address, but we do not want to have him to stay away from his own address, which is in the same apartment. He does not want any contact with Ms. Felders. And Your Honor, I believe that given the string of dismissals, Your Honor, my client is presumed innocent, and Your Honor should not rely on any arrests that have not led to convictions. I believe that the state's bond recommendation is punitive and excessive for someone who is presumed innocent. I am requesting, Your Honor, a signature bond. If Your Honor determines that he is ineligible, then I would ask for a bond of no more than $2,500 in total. That would be $2,000 for battery, family violence, first offense, and $500 for the cruelty to children. And again, we are unopposed to any stay away and no contact provisions. Thank you, Your Honor.
Ms. Salette.
And
Your Honor, I do apologize, ASG Salette. I did want to let the court know that Mr. Felders informed me that the children are actually in his custody. They live with him. Thank you.
Your Honor, unfortunately, I do not have the name of the second child. That was not in the report, as the Courtney Felders is the one that actually saw the incident. But I believe Ms. Hackworth, if she wants to speak, that she could give us the name of the second child, Your Honor.
And Ms. Hackworth, if you would like to address the court, this is your opportunity. You do not have to address the court. If you would like to address the court, you'll need to unmute yourself and activate your camera, and I'll have to swear you in.
I do.
Can you activate your camera, ma'am?
It's saying you cannot start your video because the host has disabled it. Okay, there it goes.
Raise your right hand for me, ma'am.
Sit down, baby.
Okay, do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, you can put your hand down. What would you like to tell the court, ma'am?
First of all, Courtney does not have custody of either of my children. He's lying. He does not live at 4504 Parkview Square. He uses that house as an address because it was an empty house that was next door to the house we live in at 4502 Parkview Square. I mean, just mostly everything he's saying. His bank account has $39,000 in it.
Your Honor,
Felders is let out.
Okay, hold on, Ms. Hackworth. Tell me about the incident.
Okay.
All right, go ahead.
I came home after being approved for an apartment. I came home to get ready to go to work. I was about, it was about 5 p.m. I have to be at work at 6. I told him that my daughter was going to daycare. I had got her approved for daycare, and they had said they would keep them at night. My 3-year-old was already at the daycare, so I was taking my 5-year-old, dropping her off before I went to work. And he got mad, saying I was trying to be slick and I'm trying to be sneaky. And that's when he started punching me in the face, dragging me down the stairs. He busted my head open the first time by punching me. The second time he busted my head open, it was when he was banging my head on the kitchen counter. All of this was in front of my 5-year-old. I told her to run. She ran, and she ran upstairs in my room under the bed. And he grabbed her by her leg and drug her from under the bed and drug her down the stairs. Then he put her in the car and he pulled off with her after he seen that my face was bleeding. He called his cousin to tell his cousin that he needed to bring my kids and himself to his house. And because the police were on their way, he was trying to get away. And he was trying to get him and the kids back to Wisconsin. This is the third altercation that we had in that week. He just keeps going and going. So like at this point, he's going to kill me. I do need help because he's gonna kill me.
All right, thank you.
The last case we had was dismissed.
Objection, Your Honor. I believe it's beyond the scope of what Your Honor had asked about this incident, Your Honor.
All right, I think I understand the situation, Ms. Hackworth. I appreciate it. Okay, thank you. Anything further from counsel?
Nothing from the defense, Your Honor. Again, my client strongly denies the allegations and he's presumed innocent.
And Your Honor, if you would let Ms. Hackworth continue to speak, I think it would go towards the IALA factors, Your Honor.
I'm already gonna make him stay away from her and the children, and so I believe I have enough information regarding the other matter. So as far as the battery family violence, it's going to be a $5,000 good bond. Cruelty to children is going to be a $2,000 good bond, makes for a total of a $7,000 good bond. No further contact with Ms. Hackworth. No further contact with the minor children. No drugs, alcohol, or weapons while out on bond. Mr. Felders, let me make it quite clear what no contact means. No contact means no personal contact, no phone contact, no email contact, no contact over any type of social media, no contact whatsoever. If it gets back to this court that you have been in contact with Ms. Hackworth or the minor children, then this bond is going to be revoked. Good luck to you, Mr. Felder. Good luck to you also, Ms. Hackworth.
Can we get the name of the second child?
I believe that we should just put in the 2 minor children since they're,
Okay.
as far as not having their names in the.
Thank you, Your Honor.
Position 3, Chavez.
Good afternoon, Mr. Chavez. I'm Judge Eric Mora. This is the State Court Expedited Accusation Calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
Thank you. You've been charged in case 22 CR 006637Y with driving under the influence of alcohol, a concentration of 0.08 grams or more, and driving under the influence of alcohol less safe. Is your history, Mr. Howard?
His 5th arrest. Last was 2020 DUI, possession of a controlled substance. He's on probation for both. 2014 probation violation. 2016 possession of a Schedule 1 or 2 controlled substance, and a 2014 shoplifting conviction.
All right, thank you. Ms. Salette?
Yes, Your Honor. Officer Wells from Roswell Police Department was patrolling the area of Woodstock Road Street in Roswell, Georgia, around 11:57 p.m. when he ran the tag of a Volkswagen Jetta, and the tag came back registered to a Joshua Chavez, who had a probation violation warrant out of Cherokee County for the DUI conviction. It also stated that he was on a limited permit, that he was only to be driving to and from work. Officer Wells was able to identify the driver of the Volkswagen as Joshua Chavez based on the defendant's license photo in the GCIC. Officer Wells pulled the defendant over and detained him so he could confirm the warrant out of Cherokee County. Officer Wells noticed an odor of alcohol on the defendant's breath and that his eyes were bloodshot. The defendant agreed to complete field sobriety tests, and Officer Wells noticed clues of impairment. The defendant was placed under arrest and read implied consent and agreed to take a breathalyzer, and the defendant blew a .265. Due to the defendant being on probation for DUI and him having been on a limited permit and has now picked up another DUI charge, the state is recommending a $3,000 surety bond on each charge, DUI per se and DUI alcohol less safe, no driving, no alcohol, drugs, or weapons while out on bond. The state believes that the defendant has shown that he cannot obey the orders of probation, and he was given a chance with having a permit, and so the state believes a no driving recommendation at this time would be appropriate, Your Honor. Nothing further from the state.
Thank you, Ms. Gann.
Thank you, Your Honor. Mr. Joshua Chavez is 39 years old. He has been in the Atlanta, Georgia area for about 30 years. He does have family here. Mr. Chavez graduated high school. He also has 2 years of college in computer science. He is currently employed at the Big Oak Tavern as a chef. He has been in that position since March of 2022. He denies the allegations, Your Honor. He is presumed innocent at this point. I would object to the state's reading of his blood alcohol. The state has not laid a proper foundation for that. I do acknowledge my client's history. However, Your Honor, he states that he was in fact working. He states that his work schedule, he goes in around noon and he gets off at 11 p.m. So he was in fact driving home from work. I am requesting a signature bond on Mr. Chavez's behalf. And if Your Honor determines that he is ineligible, I would ask for a $6,000 split bond, $3,000 for the DUI 0.08 and a $3,000 signature bond for the DUI less safe. And again, we are opposed to any driving restrictions that are not in accordance with its privileges through DDS at this point. Thank you, Your Honor.
All right, so for the DUI 0.08 grams or more, a $3,000 good bond. For the less safe, $1,000 good bond, makes for a total of a $4,000 good bond. No drugs, alcohol, or weapons while out on bond. And he was given the opportunity to only drive to and from work. And he has these additional charges. So at this time, there's going to be no driving until this matter is resolved. Good luck to you, Mr. Chavez.
Thank you, Your Honor.
Position 2, Capizali.
Good afternoon, Mr. Is it Papazali?
Capizoli.
Capizoli, good afternoon, sir. I'm Judge Eric Moore. This is the state court expedited accusation calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes. Yes, Your Honor.
Thank you. You've been charged in case 22 CR 006636E with battery family violence. Pretrial has informed me that this is his first arrest. Ms. Select.
Yes, Your Honor. On September 21st, 2022, Officer Ross with the Alpharetta Police Department was dispatched to 140 Ketten Way, Alpharetta, Georgia. And he took out warrants for battery family violence for the defendant intentionally battering the victim, in this case, Angelo, Angelo Capozzoli, Capozzoli, by striking the victim several times with his fist, causing visible injury to the back of the victim's head. The defendant and victim reside together. Due to the nature of the charges, the state is requesting a $4,000 surety bond, no contact with the victim, stay away from the incident location, that 140 Ketten Way address, and that's KETTONWAY. No alcohol, drugs, or weapons while out on bond, and 1-day anger awareness class.
Ms. Karen.
Thank you, Your Honor. Mr. Matthew Capozzoli is 24 years old. He has been in the Atlanta, Georgia area his entire life. He has family here, including his parents and a sister. Mr. Capozzoli completed high school and is 8 classes away from earning a bachelor's in pre-entrepreneurship. He's at Georgia State and has a GPA of 3.0. Your Honor, he's currently employed at Frontera Mexican restaurant. He has been that company for about 10 months. He strongly denies the allegations. He states that he was acting in self-defense as he felt threatened by his father. He wants contact with his father, but I was unable to reach his father. Therefore, we will defer to the court's ruling. I am requesting, Your Honor, a signature bond on Mr. Capozzoli's behalf, given that this is his first arrest, and we are, again, opposed to the no contact and the stay away orders. However, without making contact, we will defer to the court's ruling. And if Your Honor order a stay away, I would ask for a one-time law enforcement escort. Thank you, Your Honor.
It's going to be a $3,000 signature bond through pretrial, 1-day anger awareness. Until someone speaks to Angelo Capozzoli, it's going to be a no further contact and a stay away. He can go back to that location on one occasion with law enforcement to retrieve any belongings that he might have there, and no drugs, alcohol, or weapons while out on bond. If someone speaks to the alleged victim, then I'm happy to make a modification if that's what he desires. All right, good luck to you, sir.
Thank you, Your Honor.
Thank you, Your Honor.
You're welcome.
Position 1, Andrews.
Good afternoon, Mr. Andrews. I'm Judge Eric Moore. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you, Mr. Andrews. You've been charged in case 22 CR 006635G with simple battery family violence. Is there a history, Mr. Howard?
7 total between Massachusetts and New York. Last arrest was 2012. Operating without a license. He had an 08 failure to pay fine. That's the Massachusetts history. As far as New York, last arrest there was 2004. Possession of a controlled substance. That's it.
Yes, Your Honor. On October 2nd, 2022, Officer Brown with the Atlanta Police Department was dispatched to 981 Forest Drive, Forrest, in Atlanta. Upon arrival, Officer Brown spoke with the victim, in this case, Crystal Andrews, and that's spelled Crystal. Andrews, Andrews. Ms. Andrews stated that she and the defendant are married and share 4 children together. She stated that she wanted the defendant to leave the residence. They got into a dispute and the defendant began pushing her. The victim's son tried to stop the defendant from pushing her, but the defendant pushed the son's arm out of the way and continued to try to pursue the victim in this case. Ms. Andrews and the defendant's 12-year-old daughter and 16-year-old son witnessed the incident, and they were visibly upset when Officer Brown arrived on the scene. Officer Brown could also smell the odor of alcohol on the defendant's breath, and the defendant was arrested at that time. And due to the nature of the charges, the state's recommendation is a $3,000 surety bond, no alcohol, drugs, or weapons, no contact with Crystal Andrews, and stay away from the incident location, 1-day anger awareness, and third-party exchange for the kids. I do believe that Ms. Andrews is on, Your Honor, if you want to hear from her when it is appropriate.
Thank you. Ms. Gannett.
Thank you, Your Honor. Mr. Kamel Andrews is 40 years old. He has been in the Atlanta, Georgia area for about 2 weeks. He states that he relocated here with his wife from Massachusetts. Your Honor, my client is married. He states that he has been with his wife, Mrs. Crystal Adams, the complaining witness, for 22 years. I'm sorry, they've been together for 22 years, married for 10 years. They share 4 children, ages 18, 15, 13, and 12. Mr. Andrews also has additional family members here in Atlanta, Your Honor. He obtained a GED. He states that he is employed at HelloFresh. He just found that job 1 week ago. In fact, he's still on probation and needs to get back to work. He denies the allegations, Your Honor, and I am asking or requesting, given my client's lack of convictions for violence. In fact, his history is quite remote, traffic offenses. I am requesting a signature bond. My client wants contact. Therefore, I am opposed to any stay away and no contact provisions. However, Your Honor, I have not spoken with Ms. Andrews. And this concludes my argument. Thank you, Your Honor.
Ms. Andrews, I see you on the line. If you would like to address the court, now is your opportunity, and you're not required to, but if you would like to address the court, okay. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yeah.
Okay, you can put your hand down, ma'am. What would you like to tell the court?
As I told the advocate when she called, this is not an everyday occurrence. This is not something that happens all the time. I really believe it only happened because he was drinking and we were arguing. He was really upset. My kids are not scared of him. I am not scared of him. I do not want him to not be able to see his children. I don't want that at all. When it comes to us, we have other issues that has nothing to do with violence. So I will be filing for a divorce from that. But I don't think there should be a stay away because I'm not scared of him. And this is not something that has happened. And my kids are not scared of him. Everyone was just really upset about the night. And that is what that is. He's not usually a violent person. He's a very good father. He did just start working on Friday. And I actually just started my new job today. So when it comes to bail bonds, he doesn't have it and neither do I.
Okay. And you both live at the Forest Drive address, is that right?
I'm sorry?
You both live at the Forest Drive address?
Yes, sir.
And do you want him back there?
He can come back. That is fine. Like I said, I will be filing for divorce regardless. So that has nothing to do with this. He can come back. Like I said, I'm not scared of him. Neither are my kids. This was a one-off thing. This is not something that happens all the time. And that's where I'm at with it.
Ms. Salette?
Your Honor, Ms. Andrews, did you tell someone from our office that you only wanted contact with him in regards to the kids?
When she asked me that I want him, go ahead, I'm sorry.
Objection, Your Honor. Ms. Andrews has testified and made her wishes clear to the court.
Okay, well, Ms. Salette can clarify if she wants to, if there's anything to be clarified.
Okay, that's fine. When I was told no violent order, I said, okay, that's fine. We can do that. I didn't realize that even with a no violent something that means that he can't like be around his kids or be like, I'm not for that because he is a good father. If he's got to come back, that's fine. As I said, and I said on the phone to the advocate, this is not something that is a continuous occurrence. This is not something that happens. I am not scared of him, and I let them know that as well, and neither are my children.
Okay.
Their children love him. My son actually cooked last night and said he was putting a bowl to the side for his father when he came home. So that can let you know that his children are not scared of him. The night was what it was. I really do believe that he needs assistance, you know, to learn how to conversate, and that's fine. Other than that, there should be no reason why he shouldn't be able to be around his kids.
Anything further, Ms. Salette?
Your Honor, the state would just ask that there be no contact with him, the victim in the case, and there can be contact with the kids or a third-party exchange with the kids, but the state would ask for no contact with Miss Crystal Andrews. But I understand the discretion of the court, Your Honor.
All right.
Can I say one more thing? I'm sorry. Can I say one more thing? I'm sorry.
Yes, ma'am.
There can be no third party anything because there is nobody to be a third party anything. And again, as I said, I am not afraid of him, and neither are my children. And in order for him to have contact with my children, he would have to have contact with me. And I'm not going to stop him from seeing his kids. I'm not going to stop him from being around his kids. I'm not going to do that.
All right. Thank you, Ms. Andrews. It's going to be a $3,000 signature bond through pretrial, 1-day anger awareness, no further violent contact with Ms. Andrews, and no drugs, alcohol, weapons while out on bond. Good luck to both of you, Mr. and Ms. Andrews.
Thank you, Your Honor.
Who do we have next?
All right, Judge, quick announcement for position 18 and 19 is going to be a medical reset.
Okay, and so that's our medical reset until 10/4.
Yes.
Actually, Your Honor, I would like to request for a breakout room for briefly for this case. And yeah.
Okay, so well, he's not there, Ms. Kim. So if you don't have a waiver, there's nothing I can do at this point in time.
Your Honor, I would join Ms. Kim in requesting a breakout. This case has been continued for almost a week, and so we do have some concerns.
Okay. All right. So we will speak on that when we go into the breakout room for a couple of other cases that. Oh, no, I guess those are the only two. Okay. Any more announcements?
That's the judge, and the rest of the positions are at South Annex. And we're completed here in courtroom 2.
All right. Thank you so much. We'll see you tomorrow.
All right. Thank you, Judge. See you tomorrow.
Okay. Let's go ahead and let me do the waivers, and then we'll go into the breakout room.
And I do have the waivers already.
Okay, we do have the waivers already. So let's go to position number 9. Martha Lowe. Mr. Howard, is there a history?
For what number?
Position 9.
Low, yeah. 7 total. Last arrest was 1997 for aggravated assault. So everything else is in the 90s or 80s.
Okay, and tell me about position 10. Mackenzie, is there a history?
3rd arrest. Last was June 2021. Carrying drugs, weapons through the guard lines. Terroristic threats. That's open out of Clayton County. What else? That's it. So
right.
he was arrested on the 25th for the terroristic threats, and I guess he picked up the other charge once he went through the jail. So that's all.
All right. So Ms. Satola, let's start with position number 9. Ms. Lowe, is that your case?
Yes, Judge.
Okay.
Okay. Yes, Judge. On September 26th of this year, FedEx delivered a package to the Commons at Imperial Hotel for the victim, Miss Edwards Rowland. That same day, the defendant was caught on camera picking up and walking away with the package which belonged to Miss Edwards. The state's bond recommendation is a $3,000 signature bond through pretrial with conditions of staying away from the incident location, 355 Peachtree Street, Northeast Atlanta, Georgia, 30308. No further contact with the victim, Roland Edwards, and no drugs, alcohol, or weapons while out on bond. And Judge, the defendant, the state is requesting for a signature bond due to the defendant not having any convictions over 20 years, and none of the arrests were theft related.
All right, any objection to any of that, Ms. Gant?
No, Your Honor, no objections to this signature bond, Your Honor. However, Ms. Lowe informs me that she resides at the incident location. Apparently it's a residential complex. She lives there, so we are opposed to the stay away, and we are unopposed to the no contact with Mr. Edwards.
Is there an apartment number? Was this taken from outside of an apartment, or was it taken from someplace else, Mr. Toley?
Well, Judge, when I Googled the incident location, a hotel came up, but there were several other things, but I did see a hotel. But if the defendant is alleging that that's where they stay, it's an apartment complex, then it could be.
All right, so the signature bond is going to be through the jail, $3,000 signature bond through the jail. I'm not going to keep him away from his apartment, but he's to have no contact with Mr. Edwards, and he's to stay away from Mr. Edwards' apartment, and no drugs, alcohol, or weapons while out on bond. Okay. So let's move on to position 10, Mackenzie. Mr. Toller, is this your case also?
Yes, Judge, it is.
You can proceed.
Okay. Judge, on October 1st at approximately 4:00 a.m., police were dispatched to a residence in response to a fight call. The defendant approached the vehicle where the victim, Ms. Morton, was seated. She charged towards the victim and punched her in the face, leaving a gash on her face. An eyewitness, Kahira Easley, corroborated that the defendant struck Ms. Morton, who was sitting on Kahira's lap at the time. The officer observed text messages on Kahira's phone that showed that Kahira blocked the defendant, and the defendant stating that she was going to pull up to the above location. Kahira and Easley formerly resided together. Judge, the state's bond recommendation is a $10,000 surety bond. Stay away from the incident location, 2555 Graywall Street, East Point, Georgia. And Graywall is one word, Graywall, 30344. No further contact with the victim, Nashay Morton, and that's N as in Nancy, ASHAY, Morton. And no further contact with the eyewitness, Kahira Easley. That is Kahira, and last name Easley. A completion of a one-day anger awareness course, and no drugs, alcohol, or weapons while out on bond. And Judge, the state is concerned that the defendant is a danger to the community, and she runs the risk of reoffending, considering the violent nature of this current offense, in addition to the open case in Clayton County for terroristic threats and acts against the eyewitness, Kahira Easley, in this current case. And Judge, I called Clayton County DA's office, and they stated that there's a no contact order with the eyewitness in this case, Ms. Easley, yet the defendant violated that order on October 1st.
Okay, Ms. Gant.
Thank you, Your Honor. Ms. Davion McKenzie is 22 years old. She has been in the Atlanta, Georgia area her entire life. She does have family here, Your Honor. She completed high school. She is currently employed part-time at Dick's Distribution. Your Honor, she denies the allegations. She states that regarding this particular incident, she was actually called to go over there to be with her girlfriend. She states that when she got there, she had no idea that Ms. Morton nor the witness would be there. She states that things escalated. She was jumped by 5 people and that she was merely defending herself. Your Honor, Ms. McKenzie is presumed innocent in this case. Your Honor. I did not hear about any convictions whatsoever for violence. She's presumed in any open cases as well. I believe that the state's bond recommendation is excessive. I am requesting a signature bond on Ms. McKenzie's behalf, and if Your Honor determines that she is ineligible, then I would ask for a bond of no more than $1,000. We are unopposed to any stay away and no contact orders. My client does not want any contact, Your Honor. Thank you.
And Judge, I would like to reiterate that she currently violated a bond condition for a Henry County case against the eyewitness. And again, she did know that they would be at the location. She, in fact, went back and forth through text message with the witness prior to coming to the location. So the state would like to enforce the $10,000 surety bond.
All right. It's going to be a $3,000 good bond. No further contact with Morton and Easley. Stay away from the Great Wall address, and no drugs, alcohol, or weapons while out on bond. Okay, Ms. Champion, are you there?
Yes, sir.
Would you, I think that we still have positions 14 and 17 at the South Annex. Are they online?
Yes, they are.
Okay, I do see them now. So if they're ready to go, then we'll do the 2 at the South Annex before we go into the breakout room. South Annex, are you there? All right, so Ms. Champion, while I'm in the breakout,
Your Honor.
Says that the internet is still not up at the South Annex. Yes, Ms. Gant, I'm sorry.
That is the message that South Annex relayed to me, that they still do not have internet connectivity, and that was about about an hour ago.
All right. So let's go into the breakout room and discuss that one case, and then we'll decide what to do when we get back. So who all needs to go into the breakout room?
I would also ask Ms. Satole be allowed to come into the breakout as well.
Okay, so Ms. Atole, Ms. Falk, Ms. Kim, and myself. Okay. Let's see, Ms. Gant, are you there?
Yes, Your Honor.
We addressed all your cases? Just-
Yes, Your Honor.
I thought so. And Ms. McLeod, Ms. Stapleton, position 17, that's your case?
What is the name, Your Honor?
Stapleton, Tone Messia.
I have a Miss Stapleton.
Okay.
And I also have, she's at the South Annex. I also have Mr. Walker.
I don't have a Walker on my calendar.
Mr. Handsome Walker. No.
Walker was an NOD, Your Honor, and that has been filed with the jail as well as the clerk's office.
All right. So we just have Stapleton.
Miss Stapleton, I filed a waiver for her because the South Annex was having problems and she's at the South Annex.
Let's see. And did you get that to Miss Bridgewater?
I did, Your Honor. I emailed it to her.
All right, very good. It's my understanding that this is Miss Stapleton's first arrest.
Yes, Your Honor.
And who's presenting for the state?
For which position, Your Honor?
Position 17, Ms. King.
It will be me, Your Honor.
You can go ahead.
This offense occurred on October 2nd of this year. Officers were dispatched to 2203 Peachtree Landing Circle in Fairburn in reference to a fight call. Upon arrival, they met with the victim, in this case, Michael Ware. First name traditional spelling, last name W-A-R-E. He stated that his girlfriend, who was the defendant, hit him in the back of the head with a bottle, and the officer noted that he was bleeding at the time of arrival. He stated that they were arguing, and when he turned to leave, that's when the defendant struck him. While the defendant does not have any criminal history, the state is still concerned about this injury, about the leaking of the bleeding from his head, Your Honor. The state is requesting a $4,000 surety in this case, no further contact with Michael Ware, and a stay away from the incident location at 2203 Peachtree Landing Circle address, as well as no drug, alcohol, or weapons while out on bond.
Your Honor, my client totally denies the allegations. She tells me that Mr. Ware attacked her, he pulled her hair, choked her and pushed her down. She was just simply trying to defend herself against him. She is 29 years old, Your Honor. She has a bachelor's degree. She is gainfully employed, and this is her home. She tells me that he took her phone and he took her car keys, which she's anxious to get back, both of them. She tells me that he really is from Chicago. The relationship has ended and he just won't leave her alone. And she plans to get a restraining order against him, Your Honor, because she says that, the situation cannot continue. He keeps coming around, even though she has asked him to leave her home. And he currently has her cell phone, currently has her car keys, and she needs to get those things back, Your Honor.
So do they both live at the Peachtree Landing address?
No, Your Honor, it's her home.
Your Honor, it was communicated to law enforcement that they both lived there together.
Okay.
It's her home. The lease is in her name. She tells me that he comes there sometimes, that he does not live there, and they are no longer in a relationship. And that is the source of part of their problems. She keeps asking him to leave, and he says he's just not going to leave.
Well, I guess she'd have to go, if they both live there, she'd have to go through the eviction process, right? So I'm gonna allow her a one-time escort to go back there. If he's not there, then I guess she can stay. If he is there, then she's gonna have to gather her belongings and find someplace else to reside, because she's not to have any further contact with Michael Ware.
Right, she doesn't want to have any further contact with him, Your Honor.
So it's going to be a $3,000 signature bond through pretrial, one-day anger awareness, no further contact with Michael Ware, the one-time escort to Peachtree Landing. If he's not there, then she can reside there. If he is there, then she necessarily can't, and no drugs, alcohol, or weapons while out on bond.
Thank you, Your Honor.
Okay, and I think that completes the calendar for today. We need to, what's that? We dealt with that in the breakout. And can you get that when Ms. Bridgewater goes over the calendar? Okay. Mr. Howard is in court with me. That's if you're all wondering who I'm talking to. And whenever you're ready, Mr.
Okay, good afternoon, everyone. Once again, the reset date for the SAP calendar is going to be October the 18th. Position number 1 is reset further notice with a $3,000 SOB through pretrial. Position 2 is reset further notice with a $3,000 SOB through pretrial. Position 3 is going to the SAP calendar with a $4,000 total good bond. Position 4 is going to the SAP calendar with a $5,000 good bond. Position 5, SAP calendar with a $7,000 total good bond. Position 6, reset further notice with a $3,000 SOB through pretrial. Position 7, reset further notice with a $2,000 SOB through pretrial. Position 8, reset further notice with a $4,000 total SOB through pretrial. Position 9, reset further notice with a $3,000 SOB through the jail. Position 10 is going to the SAP calendar with the $3,000 good bond. Position 11, SAP calendar with the $2,750 total good bond. Position 12, SAP calendar with a $5,000 good bond. Position 13, reset further notice with a $3,000 SOB through pretrial. Position 14, reset further notice with a $3,000 total SOB through pretrial. Position 15, reset further notice with a $2,500 total SOB through the jail. Position 16, going to the SAP calendar with a $7,500 good bond. Position 17, reset further notice, $3,000 SOB through pretrial. The Washington cases.
It's for the
First one is $1,000 good bond, and the second one a $2,000 good bond. And position 20, reset further notice with the $5,000 SOB through the jail. Are there any questions, comments, or otherwise?
Okay, are we all good? All right, thank you all. We appreciate it, and I will see you tomorrow. Y'all have a good day. Be safe.
Thank you. Good afternoon. Good evening.